is dated 15th of February 2024.
Yes, ma'am.
We are now on the 11th of March.
Yes, ma'am.
In the last 26 days, what extent of matching has been done by you? What steps have you taken in the last 26 days? The application is absolutely silent on that.
We can.
Now, this is the statement making headlines in India today. The Supreme Court has rejected the State Bank of India's plea seeking an extension to furnish electoral bond details. In a public hearing, the Apex Court concluded that the top bank had information sufficiently available and that they now need to disclose it by the end of business hours on Tuesday. The member bench also instructed the Election Commission to compile and upload all information by the 15th of March.
The miscellaneous application filed by SBI seeking an extension of time for the disclosure of details of the purchase and redemption of electoral bonds until 30 June 2024 is dismissed.
It was a big hearing. Several claims were made by the defendant, the biggest of which being the bank does not have enough time to verify each bond payment. The State Bank of India highlighted the challenge in reconciling donor details and redemption details, which it claims were stored in separate information silos. The bank's counsel, Harish Salve, acknowledged that bank had the purchaser details but explained the difficulty in matching them with the bond numbers. He added that the bank had followed an SOP to store information about the electoral bond scheme outside the core banking system. Salve asked for more time, at least 3 months, to reverse the process and avoid causing any havoc by giving out the wrong names and numbers. To this statement, Chief Justice of India, D.Y. Chandrachud, who was leading the Constitution bench, noted that the bank has all details kept in a sealed cover at its main branch in Mumbai. Justice Sanjeev Khanna also added to the remark.
Now, paragraph 10, you specifically say that all the purchases details have been kept in a sealed cover.
Yes.
In the main branch of the applicant bank.
Correct, my lord.
Just have to simply open up the sealed cover and
My lord.
collate the names and give the details.
The details sought from SBI include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased. Details of each electoral bond encashed by the political parties, including the date of such encashment, were also asked to be discussed. Now, the bench also ordered that even though they are not exercising the contempt jurisdiction, they have placed SBI on notice that the court will proceed against it for willful disobedience if it does not comply with the timelines indicated. In its landmark February 15th judgment, the Supreme Court held the electoral bond scheme unconstitutional and said that it violates the citizens' right to information. For all the latest news, download the WION app and subscribe to our YouTube channel.